In the past, some have tried to challenge the bar exam requirement through the courts. The U.S. Supreme Court has held that there is no federal right to appear before state courts without meeting state bar requirements. In essence, the federal courts have dismissed these challenges because there was no material issue of federal law. However, those cases were argued incorrectly. The issue is not whether one has the right to practice law without being licensed by the state. The real issue is whether citizens have the right to choose whomever they want to represent them, or are they relegated to choosing counsel from a prescribed list of attorneys licensed by the states. The Sixth Amendment guarantees that in all criminal prosecutions, the accused shall have the assistance of counsel for his defense. Included in the right to counsel is the right to counsel of choice. In U.S. v. Gonzalez-Lopez, the U.S. Supreme Court held that the Sixth Amendment guarantees that the accused be defended by the counsel he believes to be best. The majority opinion in Gonzalez-Lopez elevated the right to counsel of choice to the same level as denying a criminal defendant the rights of counsel, self-representation, or a public trial. The court declared that denying a criminal defendant the right to counsel of choice is not harmless error. It's reversible error. In other words, depriving a criminal defendant of the counsel of his choice violates the Sixth Amendment without any additional showing of prejudice. In Wheat v. United States, the court held, in dicta, that the Sixth Amendment does not permit a criminal defendant to choose counsel who isn't admitted into the state bar. However, this is incorrect. The word counsel as it applies to the Sixth Amendment does not mean someone who has passed the bar exam and is licensed by the state. The original intent of the word counsel was a much lower standard at the time that the Constitution was founded. At the time that the Constitution was written, there were no bar exams or license requirements by the states. Anyone could practice law so long as they were minimally competent. The licensing requirement did not come into play until much later when the American Bar Association began to influence the judiciary. There is nothing in the Constitution that restricts a citizen's choice of counsel to attorneys licensed by the state. At the time that the Constitution was founded, anyone could practice law so long as they were minimally competent. In a separate video, I will give an overview of the history of the legal profession to provide a framework for understanding the word counsel. In Gonzalez-Lopez, the court recognized that trial courts have been given wide latitude in balancing the right to counsel of choice against the needs of fairness and against the demands of its calendar. However, courts should not be given wide latitude. The right to counsel is a fundamental right, at least in criminal cases. This isn't a privilege granted by the states, such as driver's licenses. This is a right that is guaranteed by the Constitution. The correct standard should be strict scrutiny. In that case, the bar licensing requirement would have to be narrowly tailored to achieve a compelling state interest. State courts have a policy interest in protecting the efficient use of judicial resources. It would be a burden on the states to allow anyone to practice law who didn't understand the basics of the legal system. Accordingly, courts are permitted to set minimum standards of competency to practice law. However, bar exams and state licensing requirements go too far. Bar exams do not test minimum competency. Bar exams are competitive in nature, focusing on rote memorization and elimination skills rather than clinical capacity. Bar exams are generally not written by professional educators or examiners. Bar exams are written by practicing attorneys who generally have no expertise in drafting or evaluating tests. In the real world, no attorney is required to cite the law precisely without the benefit of consulting written notes. Nor does any courtroom require attorneys to answer 400 multiple-choice questions. There is absolutely no correlation between the bar exam and one's ability to practice law. In the video in which I discuss the history of the legal profession, I explain how it was once the dominant view that having a law degree was sufficient proof of minimal competency to practice law, without any examination. There is no compelling policy basis for requiring the bar exam, nor are bar exams narrowly tailored. Bar exams, sound legal minds from the legal profession, which ultimately deprives citizens of access to counsel. Under the U.S. Constitution, each citizen is guaranteed the right to counsel. There is nothing in the Constitution that restricts a citizen's choice of counsel to attorneys licensed by the state. Each citizen is entitled to counsel of his or her own choosing. As I stated in the beginning of this video, the constitutional issues pertaining to the bar exam requirement have never been properly raised in federal courts. If these issues were raised, I would imagine that the courts would have to do a balancing test. Courts would have to balance the state's interest in preserving judicial resources against citizens' right to their counsel of choice. If the correct standard were applied, it would be clear that bar exams infringe on citizens' right to counsel of choice under the Sixth Amendment. Furthermore, bar exams exceed the scope of what's necessary in order to preserve judicial resources. Based on this analysis, the bar exam requirement is unconstitutional.